Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer in Alabama, and we've been going through answering some of the comments, and I've been doing those kind of one at a time, and I thought, well, maybe, assuming I can do this right, technologically speaking, I thought, well, we'll put the comments up. I'll just kind of go through my YouTube channel and see if we can answer the question. That way you can see the question also, see the comment, and over here you can see which video it went to. I've tried to make the text big enough, so hopefully this is readable for you. And I'm not sure how long we'll do this. I'll just go till it seems like the right time to stop or I run out of questions. So definitely keep asking questions, making comments. If you want to know about these new videos, if you're not already subscribed, just hit the subscribe button and that way you'll be notified. Okay, so first one, and this is in the context of credit reporting by B.B. Brodus. I am so afraid of my Social Security info sent in the mail. And look, I totally get that. We have to be very careful about that. I think what he's referring to, or she's referring to here in the video, is when you send a dispute letter to the credit bureaus, you want to put your name, your address, your date of birth, and some form of your Social Security number. Now, some of the credit bureaus say put the entire Social Security number. Experian sometimes will claim that they reject a dispute letter because of that. We only put the last 4 digits. And now again, that can still be scary because they've got your name, address, date of birth, Social Security number. But if you're sending this certified and you make sure you're sending it to the right address, we've never had a problem with one of our dispute letters not making it to the credit bureaus. Now, the alternative is to do it online. My concern with people doing it online is unless you think really carefully about this, you'll lose a lot of your proof as to what actually happened. So, people say, hey, John, I disputed this. I go, well, what'd you say in your dispute? They go, well, I think I said, and so look, I'll give you 2 ways to do it. One is as you go through each screen, take a screenshot of your laptop. And, whatever, if you have a Mac or a PC, just whatever the screenshot is. Or if you have some recording software, and usually you can get this for free, kind of like I'm doing right now, I'm recording my screen. Just do that once you log in to do the dispute so you have an entire movie and you can show exactly what you said. And, if you want to upload documents, you can do it. Now, sometimes you can't upload them, and that's part of the problem with doing it online. But so again, for this comment, totally understand the concern, and it's a valid concern, but that's why we send it certified mail. Okay, so the next one is Kevin Stafford. And let's see, I've used a lot of your info, saved me a lot of money. Credit card debt, $30,000, quit paying 3 years ago. And that apparently is statute of limitation in Oklahoma. Got sued for only $7,000 of it before the statute of limitation ran out. Answered a lawsuit, waiting for a court date. And he says, I was paying $1,000 a month on these, so after 3 years, I saved $36,000. If I go to court and have to pay the full $7,000, remember he was sued on 7 out of the $30,000. Still a lot better off. Wake up, put pen to paper, and would have cost a lot more if making minimum payment, which is absolutely true. You get those credit card statements, you make the minimum payment, I don't know, it's some crazy thing like it'll take 17 years to pay this off, even if you never use the card again. So definitely have to make more than the minimum payment. And so his point is, by understanding the laws, he's able to save money. Now, somebody might object to this and say, well, you should pay all your bills. I agree. We should pay all the debt that we owe. The problem is sometimes we get to where we can't pay it. Lose a job, go through a bad divorce, medical crisis, something happens. Well, then the question is, once we get through whatever difficult situation that was, what do we do then? And if we don't know the statute of limitation, if we don't understand how lawsuits work, then we're really at a disadvantage. But what Kevin's done here is really looked at it carefully and said, all right, I'm going to make the best of a bad situation and get out from under this debt. Now, bankruptcy is an option. I think it's very rare that that's appropriate, but it is an option, and that can wipe out our debt. But knowing your options is the key, and then taking action. So appreciate that comment, Kevin. Let's see, our next one is from Chris Topher. I need some advice. Signed up for Home Depot credit card. They had an offer of $100 off any single receipt purchase of $1,000 or more. Looking for $200 worth, but when I saw the offer, I decided to buy some drywall, wood, other huge items for a project in his backyard. Let's see. Also, if you buy enough drywall, the cost goes down, and that's what they call the volume discount. And so then he chatted with Home Depot rep to make sure, given the $100 promo credit, the rep said, yes, it'll show up, made the purchase, $1,100. He paid $80 for delivery because he's getting $100 off anyway. So he tipped the delivery guy. Then he's told by Citibank, who is the one really behind the Home Depot card, that the $100 promo was declined. And apparently this person realized there was a confusion between the volume discount, and I think those were all the sheets of drywall, and the promo offer. So she'll resubmit it. It's denied. He said close the account. He'd paid the balance down to $500, but it shows as $600 because they won't honor the promo. They close the account. Perfect credit, self-employed. They won't get another penny till they offer the promo. What should I do? And tell them to kick rocks. The only reason I bought all this stuff and had the delivery fee was promised $100 off. And they're saying they won't correct it and they'll come after me in collection. So, first of all, very frustrating. I get how frustrating this would be. A couple thoughts come to mind as I'm reading this, and really these comments, I'm just reading them for the first time here, is if you did an online chat, do you have a copy of that online chat? In other words, you take a screenshot to give you an option to email it to yourself. If you do, that would be fantastic. Because if you've got the Home Depot person saying, yes, you will get this discount, then I think that's a problem for Citibank when they go, no, you don't get this discount. And if you did not get the chat emailed to you, or maybe they didn't offer you that option, just remember in future situations, always get that email chat. You might call Home Depot or chat with them online and say, hey, can you pull up that chat? I bet they can pull that chat up if that was pretty recent. So, the issue is they're going to send you into the collection. If you don't pay what you admittedly owe, so if it was $1,100, you're supposed to get the $100 discount, sounds like you owe $1,000, then they've got an argument here that even if they messed up on this promo discount, you're still at fault. You still didn't pay what you owe. So if it was me, I would pay everything I owe and then say, look, guys, that $100, you got to fix that. And I'd look for that chat. Maybe you have a copy of the chat. Maybe you can get it from Home Depot. Maybe they can look it up, email it to you, whatever. But I would definitely look at that. You want to check your credit report. If this is showing up on your credit report, and I'm sure it is with Citibank, if you've got that online chat that makes it clear, you could dispute that through the credit bureaus and submit that online chat. And just like we talked about in that previous one, do it by certified, print it out, put everything together. We talked about that in other videos, but make sure you have an absolute clear copy of exactly what you sent and send it by certified and say, look, I don't owe this $100. Here's the $1,100 bill. And if you take $100 off, it'd be $1,000. Here's the proof I paid $1,000. I don't owe this money. And see if the credit bureaus will take it off. If it goes to a collector, I would notify the collector, hey, I dispute this. Here's why I dispute this. We talked about this in other videos. If we do kind of a generic dispute, well, then a debt collector just has to kind of give us a generic answer. But if you were very specific and say, look, there's a $100 promo code. Here's the chat where I was told that I would get it. I did not receive it. I've disputed this. I do not owe this money. Don't put this on my credit report. Say that to a collector. Don't collect this against me. And if they continue to do that, I think you've got a very nice lawsuit against them. If Citibank is on there and they won't correct your balance, even after you dispute it, show the chat if you have that, or ask Home Depot if they have a recording of the call. They probably won't give it to you. Although I think actually with this, there was no phone call, it's just a chat. So the key is to get that chat if at all possible. If you can't do that, then really look at the terms. go grab another copy of the credit card if it's at the Home Depot with that offer on it, and really read all the terms carefully and then submit that. And so I hope that that will help you. And this may be something where you want to get with a consumer lawyer. If you're in Alabama, you can get with us. Or if you're in another state, get with a consumer lawyer there and have them sit down and look at it and see, okay, what exactly are your options there? So hope that that helps, and thanks for that comment. So let's see. The next one is Joseph. And okay, I know this video is the one where we're talking about if a second debt collector comes after you, sues you, should you ignore it or not? And he says, I didn't see the comment, but based on what I've observed, if a judgment's entered against a person, it's typically very difficult even for an attorney to succeed at a motion to set aside the judgment. The reasons have to do with the way civil procedure works. I'll never understand why people take this, quote, devil may care, quote, approach and or attitude toward legal proceedings a lot more serious than people realize, jurisdictions and actual things. So great comment there from Joseph. And I'll say this, it is very difficult. When you have a judgment against you, it's very difficult to set that aside, except for a few things. If you were never served, and if you can prove that you were never served, and sometimes that can be a challenge because we're kind of proving a negative here, but if you can prove you were never served, at least in Alabama, I think in every state, then you can attack that judgment at any time. If there's a judgment against you and it's just because, I forgot to answer, you have very limited time where you can go back to the court and say, please set this judgment aside, this default judgment. I made a mistake. I should have answered. Here's what happened. And obviously, you got to know the rules of your state for how that happens. But if it's, let's say that you don't owe the debt at all. Okay, so I don't owe Citibank. Let's just use that as an example. And Citibank sues me. And legitimately, I've never owed Citibank $1 in my life. They sue me. I get served with the lawsuit, and then I just ignore it. Like, wow, they can't do anything. I don't owe this debt. This is bogus. And they get a judgment against me, and the time is run to ask the court to set that aside because of a mistake. I'm stuck with that debt. Might be $1,000, might be $41,000. I'm stuck with that debt. Now, somebody goes, but that's not fair because you really don't owe it. Yeah, I don't really owe it, except now I do because there's a judgment. So you've got to take this stuff very, very seriously. And I appreciate this comment from Joseph here. All right, so let's see. Tommy Gunn. Thanks for great info. When sued in Alabama by an original creditor, so we're not talking about a debt collector, just an original creditor, as an open account, not account stated, what must they prove to show ownership and amount? Are they required to show the full accounting of the balance from zero to current? If so, what's the argument for that in court? Also, how can I get them to show everything they have and not be ambushed at trial on small claims? Thanks for your time. Eager to hear back. So, great question, Tommy. So, again, we're talking about original creditor, not a debt collector. And what Tommy's referring to here is there's in the law, we call it a cause of action. So in a car wreck, your cause of action would be negligence. It might be wantonness. There might be drunk driving involved. A bar served somebody when they knew they were drunk. So we call that a dram shop violation. All different types of things. These are called causes of action. Well, when you're sued on a debt, it could be breach of contract, account stated, or open account. And most of these guys do it, all of the above. But here the question is, it's not account stated, so open account. So open accounts, 3 years in Alabama. And generally, they would need to show from the beginning the charges. Now, I have found most judges won't make them do that if they can show maybe the last 6 months of billing statements and you admit you got them, you didn't dispute them, you never challenge the amount that's on there, then usually they'll go with that. But I think technically they should have to go back to the beginning, and because the idea of an account stated is that it's not a, let me say it this way, and sometimes words are used in different contexts. So you might see on your credit report it says an open account. That's different than what we're talking about here. That just means the account is active. Then there could be a closed account. On a credit report, that just means it's closed. But when we're talking about types of debt, usually open account means it's open-ended. So it's like credit card. I can charge $100 today, not charge anything for a while, charge $1,000 next week. Whereas a closed-end loan would be like a car loan. You're going to pay $500 for 48 months, and that's all there is to it. Well, with an open account, it's going up and down, up and down. And so they really do have to show from the beginning. And I can get you some more details on that, Tommy, if you'll reach out to me directly. It's john@wattsherring.com. So WATTSHERRING.com. And so that's something to look at. And then how do I get them to show me everything not be ambushed at trial? In small claims, discovery is forbidden. And here's what I mean by that. Required discovery. So discovery is where we swap documents. The judge cannot allow either party to conduct discovery against the other unless you agree to it. Now, in district court, so Alabama, we have small claims, district, circuit court. Absolutely get discovery in circuit court. In district court, it's the discretion of the judge. Small claims, it cannot be required. Now, some judges will sort of have their own rule and say, well, 14 days before trial, bring whatever your evidence is, swap that with each other. But basically, small claims trial, they sort of are trial by ambush, okay? And you get there and you find out what they have. And they find out what you have when you get there. Now, you can always request it. So here's kind of a, you can't go in the front door, but maybe we can kind of get around into the back door. The collection lawyer is considered a debt collector under the FDCPA. So assuming this is consumer debt, the Fair Debt Collection Practices Act. So you could send a request to the collection lawyer, and particularly if it's within the first 30 days, but even if it's beyond 30 days, you can request verification or validation and ask these, show me copies of statements, show me the beginning balance from 0 to the current date, and whatever it is you want to ask for. And if you do that in a letter, send it certified, keep a signed copy, and then if they just refuse to give it to you, they may have violated the FDCPA. This is section 1692G. We have videos on that. But if they don't answer it, you can always show that to the judge and say, look, judge, I requested this information from them. And I told them I want from the beginning, when I have a zero balance, all the way to now where it's $5,433. And they didn't give it. And here they come into court and they've only got 5 months of statements. Well, then you may be able to persuade a judge that, yes, you actually are fully entitled to from the beginning all the way to the end. And with it being the original creditor suing you, so Capital One, Synchrony Bank, Chase, whoever it is, they should have all that information. Now, I think it said must prove they show ownership. Well, typically, and I can 99.99% guarantee you in Alabama Small Claims Court, the judge is not going to require them to prove ownership because the judge is going to say, look, do you have a Capital One in your wallet? Did you use it? That's Capital One suing you? That's all I need to know. So I think the better argument's on that from 0 all the way to the end, and maybe request that from the collection lawyer. So hope that helps, Tommy. And if you have more questions or want to talk directly with me, just give my office a call, 205-879-2447. So let me say this about if you're from a different state than Alabama. If you're sued by a debt collector, you've got to talk to somebody in your own state. Every state's different. If you're saying, well, look, I want to sue Equifax, or I want to sue Discover Card under the Fair Credit Reporting Act, or I want to sue this debt collector under the Fair Debt Collection Practices Act, and you're in another state, I still recommend you get with somebody in your state. You can get with us because it may be we can bring that suit in Alabama, and you can certainly agree to hire a lawyer in Alabama and bring the suit in Alabama. Or we can work with a lawyer in your state to bring it in your state. But definitely on debt collection lawsuit stuff, I can give you general information, and I can tell you how it works in Alabama, but Georgia may be different, South Dakota may be different. So definitely get with somebody in your state. But since Tommy's in Alabama, feel free to give us a call. All right, so the next one here is, from IGB Productions. Who says the courts have jurisdiction? I know this is Alabama, so you might have to call reinforcement to get something done. I appreciate this info because he appears to show good intent. He is right. You can do this on your own because I know personally these liars, I mean lawyers, feel they're so smart until he gave golden advice for those willing to go distance, handle the affairs. If you know what you're doing, then you won't even make it to court. If he ain't making sense, listen till you get it. Okay, so a couple things here. Let me just take that last part. If you know what you're doing, you won't even make it to court. I think that's not true in Alabama. Maybe true in other states, but it's not true in Alabama. If you know what you're doing and the collector wants to go to trial, then you will go to trial. You will go to court. And if you don't show up, you lose. And so they may not be able to win at court based on the evidence they have, the arguments that are made, but you can't just make them go away. Now, you can persuade them to, and that's what we do in cases, is if somebody hires us in a debt collection case, we talk to a collection lawyer, we say, here's our non-negotiable settlement terms. If you want to do that, great. If not, we go to trial. It's totally up to you, and no pressure either way. So, I would just say, I don't know this person. I don't know, he says he's done some things personally here. Sometimes there's this idea that there's not really money, no debt is enforceable, and that's on a very theoretical basis. And let's just assume it's true, that there really is no debt, there's no loans, everything in America is free. Just assume that's true. I don't know any judge that would accept that because the entire economy comes crashing down if we do that. So, you do have to take it very seriously. And if you're in court, you've got to follow the rules in court. And sometimes I see people say, well, I'm going to refuse to respond in court because I have a constitutional right to not respond, and there's no such thing as money or no such thing as debt, and the judge has no jurisdiction because they didn't sue me in all capital letters or whatever it is. You know what? You're going to get a judgment, and they're going to garnish you. And I see people that maybe they have, $250,000 piece of property it's paid for. It's been in their family forever. And they're going, what's going on? They're going to take my property. This is a bogus judgment because they didn't sue me in all capital letters or whatever. And I'm like, yeah, you're going to lose. You're going to lose that property because they have that judgment against you. So take this very seriously. If you want one of these more kind of esoteric arguments about there is no debt or they didn't do it in blue ink or whatever it is, that's fine. Just make sure you are really, really confident in that, because I see so many people, they take this argument based on something they read on the internet. They get to the other side and they're garnished. They lose their property and they're going, wait a minute. So do whatever you want. Just make sure and be very careful about it. All right. So here's Golden Child. This is validation. So under the FDCPA, Section 1692G, within 5 business days, or 5 days, I should say, of the initial contact with debt collector, they have to send you what's called the validation notice. Here's the creditor, here's the amount, and give you some disclaimers. If within 30 days of receiving that, you request verification, then they have to send you some information. So that's what this question is. Do they have to provide a copy when you dispute? They keep saying verified and accurate, but don't send copy of contract. So with this, I'm assuming debt collector's written and you say, give me a copy of the contract. It depends on what we mean by the contract. If you're saying, I dealt with Capital One and now it's Portfolio Recovery who's collecting, but Capital One still owns it. If you're saying, I want to see a copy of the contract between, they don't have to provide that. But if they've sold it to Portfolio, then I think that's a legitimate request. Now, some judges don't make them do it. Some do. I would certainly request it. If they don't send it, you can follow up. Remember, validation, as we've talked about before, you send the verification, they validate it. Well, now it may come back to you and you follow up on it. And it's just back and forth, almost like a tennis game. And so you say, send me a copy of the contract where you supposedly bought the debt. And here's why I want to see it, because I don't know who you are. And they write back, go, we own the debt. We validated it. We're not giving that to you. Well, you could just drop it at that point. Or you could write them back. Explain why you're not giving me the contract. Here's why I need it. I'll tell you again why I need it. I want you to put in writing why you're refusing to give me the contract. They may just respond with the formula. We're not giving you the contract. They do it again. And so you can kind of go back and forth with them. And so whatever you're asking for, so here it's a copy of the contract. In another situation, it might be invoices. It's all different varieties. Maybe the copy of my medical bill, whatever it is. Explain why you need it. So here's a pattern. You say, I want this because, and then you give the answer. So I want to see a copy of my medical bills because my Blue Cross Blue Shield statement shows me everything's been paid. Or because I've already paid that once, or whatever it is. So here's what I'm requesting. Here's why I'm disputing this. And I need it because, and then you give the answer. So hope that that's helpful, and thank you for that comment. So let's see. The next one is Mr. Star of Truth. I got a call from a dispatcher on Friday saying he was trying to serve me from a credit card I had back in '07. He gave me a number to call. I did. The man says I owed $1,000 on a credit card. I'm no longer working, haven't worked in a year. All I get's welfare, trying to get disability, but I have a bank account. Can they take my disability money out of the bank? I already have a judgment against me from when I was working. My wages were being garnished. Do I have need to worry? Okay, so very good question. I'm sorry you're in this situation. So the dispatcher, okay, that may be a process server. So I'm not sure exactly what he means by that. Maybe it just means a debt collector has called and saying, trying to serve. I'll say this, at least in Alabama, where I practice, you don't get those kind of calls. Now, you may get a call from the process server. Okay. Now, they're not going to give you the phone number to the law firm. They're just going to say, I need to hand you papers. When can I come by your house? When can I meet you? When you get these calls where somebody says, hey, I'm trying to reach you because you owe this money and we're trying to serve you, usually those are bogus in my experience. Okay. So if you get those calls, just say, hey, send me proof in writing. And you say you're trying to serve me papers, give me the lawsuit number so I can call the court and check this out. Now, if you're in Alabama, you can call us. We'll look it up for you. If you're in another state, get the number, call the court, or call a consumer lawyer and say, can you look this up? I think what you'll find is they're going to say, no, we can't give that to you. It'd violate our privacy right. No, there's just garbage what they're saying. Or they may say, well, the sheriff's got this on his desk, and if you don't pay right now, we're going to have you served with it. Great. Give me the number of the lawsuit. It has a case number. When did you file it? What court did you file it in? What's the case number? And I'll check this out, see if it's legitimate. Send me something in writing. And they say, well, we'll email it to you. No. I want it mailed. We'll fax it to you. Nope, I want it mailed. I want you to put a stamp on it, okay? And the illegitimate ones, the scam ones, won't do that because they're terrified of sending mail across state lines when they're committing fraud. So back in 2007, credit card, that's a pretty long time ago. I would wonder if, maybe you continued to pay on it recently. But I definitely look at statute of limitations there. And so it says I'm on welfare, trying to get disability, but I have a bank account. Can they take my disability money? I assume that means the welfare money. I don't know of any specific protection that welfare checks or, sort of the dollars from a welfare check would have as far as being protected from garnishment. If you are getting disability from Social Security, that is definitely protected. So it says I have a judgment against me from when I was working. So here's what I would do, because the question ends, do I have need to worry? Yes, in a way. I mean, I would want to know who this debt collector is that's calling you, that's saying you owe this money, that's claiming that they have filed a lawsuit against you or they're trying to serve you. And then the short answer is find that information out or get with a consumer lawyer in your state to help you figure that out. Because it may be this is totally illegitimate, this debt collector. Maybe they are legitimate, but they're threatening you with a lawsuit when it's too late to sue you, and you may have the ability to sue them under the Fair Debt Collection Practices Act. So I would definitely find out your options there, and hope you're successful with your disability. If you're not using a Social Security disability lawyer, I would definitely go talk to one, and those guys can be very, very helpful to you, and so I'd recommend that. All right, let's see, Norsewood 88 video answered a lot of questions I previously asked. Thank you. Well, you're very welcome. And here's one from Better Days. And this video is on something to do with bank account being garnished. So let's see. Please help. I had a judgment 2009. Today I went to look at my bank account and was garnished. Now I have a balance of, it looks like negative $14,560. That's pretty big negative balance, and less my Social Security payment. They took my Social Security disability payment. My question is, are they going to put my Social Security payment back or not? For how long can a bank account be garnished? Okay, so a couple things. You definitely need to talk with a lawyer in your state to figure out the answer to this question, but I noticed the judgments in 2009. In Alabama, a judgment expires after 10 years. Now, they can revive it for an additional 10 years, but they've got to do that. So I've seen people threaten and try to garnish on a judgment that's expired, and that's not right to do. I think that's a violation under the FDCPA, Fair Debt Collection Practices Act. So you want to find out, is this judgment still valid? I want to say we had a case from Oklahoma, and maybe it's like 5 years, and it's gone at that point, okay? And now, there are a bunch of rules. I may be wrong on those dates. Again, get with a lawyer in your state to find that out. Now, it would be odd that your bank account would be garnished so that it becomes negative. I mean, normally, let's say you have $5,000 in your bank. They'll take all five. Now, you may have checks and things hitting that then make it negative. Now, as far as Social Security disability payment, that should not be garnished. Again, I would get with a lawyer who is familiar with the FDCPA and suing debt collectors and get some advice on how to do it. If you were in Alabama, I'd probably have you write a letter to the debt collector saying, hey, you garnished my Social Security check. Some or all of that money was my Social Security check. I want it back. Here's the proof of my direct deposit from Social Security. And tell me when you're going to get it back. You also made me get overdrawn. I want you to fix that, pay those charges. In other words, you kind of put it back on them. You put them on notice so that they can't claim ignorance. And there is a cause of action in Alabama for wrongful garnishment. And as a matter of fact, that case I mentioned from Oklahoma, we use that, incredibly successful in using that type of claim. And so when they know that they've done something wrong and they don't fix it, or they knew it was wrong before they did it, it's a very powerful law. So I would definitely check that out. And the final question, for how long can a bank account be garnished? Well, really, they can keep garnishing it as long as you owe money, as long as the judgment's still valid. And so they can continue to do that. But you definitely want to notify everybody, this is Social Security. And if the only money going in is Social Security every month and there's no other dollars in there, then they don't need to be garnishing at all. Again, I would let them know that. Sometimes what debt collectors say is, they go, well, we're going to take the money and then you prove it was Social Security and then you try to get it back. Well, if you tell them, okay, so here's the timeline, here's the past, here's the present, here's future. In the past, they may have done that, but if you tell them right now, the only money, and you show them this truth, the only money in their Social Security, then in the future when they do that, I think that's a great lawsuit under the FDCPA, and if you have a wrongful garnishment type cause of action in your state. So best wishes with that. So we have royalty here. So King Artaxerxes, I think I'm remembering that right from the 300. All right, so one video on collectors I recently watched said all the debt collectors have to do is get you to verify your name and your address when they ask, are you blank and do you live at blank? If you answer them in the affirmative, so you say yes to these two questions, then they now own this debt legally. So they said in this video to never speak to them, either hang up or don't answer calls is true. So the answer is no, it's not true. So let's think about this. So a collector calls you, and what are their obligations? Well, there's an obligation to not talk to a third party. So what's a third party? So let's say I owe the debt. So they can talk to me, they can talk to my spouse, and they can talk to my lawyer. That's it. Anybody else is a third party. So if they start disclosing the debt, here's what you owe, things like that, then they violate law. So they call my ex-spouse, violate law. They call my neighbor. They talk to my boss about my debt. They talk to my preacher about my debt. They talk to, my second cousin 4 times removed. They talk to my kids about my debt. They violated that. So a debt collector, when they're calling you, they do need to verify it's really you and that they have the right person. So the name and then the address. They might verify date of birth. They might verify Social Security. And so just saying, so imagine debt collector calls me. And they say, hey, are you John Watts? And I say, yes. And they say, do you live at 123 Main Street in Birmingham, Alabama? Yes, I do. They do not, first of all, it says own this debt. I think you mean that you now owe it. But certainly me answering who I am and where I live does not prove that they own the debt. And it does not mean I owe the debt. You know what it proves? I'm John Watts. I live at 123 Main Street, Birmingham. That's all it proves. Nothing else. Now, you do have to be careful. There are some scams out there where they get you to say your name, get you to say yes, then they kind of splice that in and say that you agreed to make a payment. You can kind of think of it like photoshopping for audio purposes here. And so you do have to be careful about that. One thing you can do, if they say the call may be recorded, well, you may want to record the call, okay? And then, it's not always easy when somebody's calling you, but, like if I was on the phone right now, I've got my laptop here, I could just open it up, start recording it. If I've got another phone, I could just do my phone on speaker, hit the voice memo or whatever it is on my other phone and record it. And so that way you've got some proof there. But if you're worried about it, you can say, I don't want to talk to you, send everything through the mail. That's certainly legitimate. I personally haven't had any clients have a problem with this as far as talking to them. Now, they may say, you admit you owe this debt, right? Well, you want to make sure you say no on that, unless you just absolutely know that they're correct about that. So they say, you admit we own it. You admit that you owe it. Well, I don't know how you would know just a voice on the phone that they own the debt and you owe the exact amount that they say. So I use the phone call as just a way to get information. So who are you? Why are you calling? What is this about? How'd you get this debt? How'd you figure out how much I owe? When did you get it? Why do you say I owe? Just the who, what, when, why, where, how type questions. And you're just gathering information. So they're using the call to try to force you to pay them. We're flipping that on them to say, it's almost like this. You go, I'm so glad you called. I've got so many questions for you. Let's get started now. And you go through and you make notes or you record the call if they say the call can be recorded. So that's the approach that I recommend. We've had great success with that over the years. But it certainly is a valid option. Say, I don't want to talk to you. Send me a letter through the mail. And that's it. So hope that that's helpful. And I appreciate it. Let's see, Tony Palmer, thank you so much for this lesson. And this is our, 35-minute video. Just kind of an overview of being sued in small claims in district court in Alabama. And from the beginning to the end, how that process works. It says, I'm dealing with debt collector in Colorado that is merciless. So definitely understand that. And, it's the same answer that we've been giving people for more years than I can think of. And I have to remind myself of this in every aspect of life. You got to figure out your options, know your rights, and then take action. See, if we know everything to do, but we don't do anything, it does us no good. So if I'm sitting in my car, I know how to get from Birmingham to Atlanta, but I never press the accelerator. I don't get there. Now, some people do the opposite. They're just like, I'm just driving, and I'm going to step on the accelerator faster, harder to make it go faster. But they may be going the wrong way. And so they're heading into Mississippi and then Louisiana and then Texas. Well, you ain't going to get to Atlanta no matter how fast you drive. So we've got to know our rights. We've got to take action. So Tony, what I would recommend is definitely keep learning about your options. Get with a lawyer in Colorado, Colorado where you are, and who does this type of work, and say, what are my options here? Should I do this on my own? Should I settle it? Should I hire you? How much will it cost? How does the process work? And just find out information. So again, hope that that's helpful, and thanks for your comment. Let's see. Dia, I hope I'm saying that right. Dia Draper. Much appreciate your videos. I just want to stop paying these credit cards altogether. I didn't use them purposely. My wallet got stolen, then everything went haywire. That was 3 years ago. The reason I got 7 credit cards because I tried to consolidate them 5 years ago. And they didn't consolidate total amount and sent me 2 different credit cards. I just kept paying on them. I just want to stop paying on them because I know there's no money. I'm on Social Security. Much appreciated. I digress. Without prejudice and recourse to the paragraph ahead, not to you using microphone. Oh, okay. I think what she's saying is she dictated this. I've certainly done that. I've dictated it, and it's like comes out. And okay. So let's talk about this. I mean, the first question is, do we owe the money? If we owe the money, then we should pay it if we're able to pay it. But if we owe the money and we just can't afford to pay it, well, then you may want to talk to them and say, here's the deal. I can't pay you this anymore. And I'm on Social Security. Can't get my Social Security. Now, do you own property? Do you have other assets? Do you have other bank accounts that they could get? I don't know if it says if working or not. It says on Social Security, so I'm assuming not working. But just find out. And if they can't touch you, sometimes people call that being judgment proof. If they can't touch you, then if they won't settle with you, you may want to look at bankruptcy. Of course, the response to that is, well, you don't need to do bankruptcy if they can't touch you. If you don't do bankruptcy, and I don't recommend that for many people, but if you don't do bankruptcy and they're just calling you, you can always send them a cease and desist letter so that they stop calling you. You can just deal with them on the phone, like we talked about in the last one, who, what, when, why, just ask them questions. They violate the law, sue them. Sue them under the FDCPA. So you may be judgment proof, but you're allowed to sue them and recover some money. Or again, you may want to look at bankruptcy or just ignore them. But if they sue you, here's where I think people make a mistake. You get sued and you're like, hey, I'm judgment proof, so I'm going to do nothing. No, it's the wrong approach. If you're judgment proof, go fight it. You got nothing to lose, right? Because if you lose, they can't touch you anyway. So go fight it. You may beat them, and that way you don't owe the money. And you may be able to sue them if they brought a bogus lawsuit against you. So I know this can be very frustrating when, we got this much in bill and this much in income, and it's like the payments I'm making are never going to get me out of this. I think we talked about this earlier. Sometimes you make minimum payments. It may say like it'll take you 17 years to pay it off. So I do sympathize with you in this situation. It can be very frustrating and almost, kind of get you down a little bit. But talk to a lawyer in your state. Find out your options. Are you truly judgment proof? Sometimes people think they're judgment proof. They're not. I've had people come in and say, they can't touch me. I don't own anything. And then at the end of the conversation, they say, now that $150,000 investment account, they can't get that, right? I'm like, yes, they can get that. So make sure you're judgment proof and then see what your options are. Maybe it's to go to the creditors and say, look, I can pay you $5 a month, but you got to bring the balance down or whatever it is. Or look at bankruptcy. Again, if you're judgment proof, really no reason for bankruptcy. And then just fight them. Maybe you're sending cease and desist letters to them and one collector stops collecting, but they send it to another. You send a cease and desist to them. And then they violate that cease and desist. Hey, sue them. Get some money for that. That's great. So hope that that's helpful, and thank you for that comment. Hope things get better soon. So here's Phillip Romain. Thanks for all your help. My situation is I responded within 30 days with a debt validation letter. So that's under Section 1692G. It's a third-party debt collector. They responded back with none of the original documents. All in-house proof of debt was provided, but none from the original creditor. I did ask for specific proof of the debt, but they respond in general information, in-house documents for proof. It hasn't been reported to any credit agencies. I'm in the middle of responding with the second letter asking to show proof of any and all original contractor documents and other item of proof to verification of the debts. If they don't show proof, what are my options from them trying to collect on this debt? So, okay, great question, Philip. So let me just make sure we're on the same page about this. When we say original documents, we don't mean literally they have to send me the original document. They can send a copy of the original document. Okay, so sometimes in foreclosure, people they say, I figured out how to stop the foreclosure. I'm going to tell them they have to mail me the original note. I want, my blue ink signature on it. They're not going to send you the original. No judge is going to make them send you the literal original document, because then you could throw it away and then they can't prove their case. So question is, are they sending you a copy of the original contract, which is what I think Philip means here. So if it's a credit card, usually there's not a literal contract that you sign, but there's the terms and condition. So where are the original terms and conditions? And if you took out the loan in 2000, took out the credit card in 2000, now it's 2019, those terms and conditions may have been changed a dozen times. Well, I want to see those, because what if on the third change the late fee went down? Well, then we would need to know, if I was late after that, before the fourth one came along, did you charge me the right late fee? How about the interest rate, the over the limit fee, whatever it is? So yes, you need the copies of the original documents from the original creditor. And I talked about this, I think, in a previous comment on the same video. Ask for, here's what I want, and here's why I want it. Give them a reason. So in marketing, a lot of times you'll see this. Somebody will say, if you buy my book, read my product, watch this video, you'll learn, blah, 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 which is important because, and so, buy this car because it has, lane assist. Well, what does that mean? Which will help you from drifting out of your lane and crashing into the guardrail. Okay. So in marketing, again, this is the feature and the benefit. Well, here you say, here's what I want, and here's why I want it. Here's why it's important to me. So that would be my suggestion. And you may be going back and forth several times. Philip, what I would do is get with a lawyer in your state that does FDCPA, dealing with debt collectors, and have them look at what you originally sent, what your verification letter sent, how they responded, what's your second letter, how they respond. If you lay all that out for a lawyer that knows what they're doing about this, they'll be able to look at it and say, hey, we can sue these guys because they violated 1692G. Or they may say, nope, they've done it right the way our judges interpret the law. This is more than sufficient. But you'll know your options. And so that would be my suggestion. Great question. Thanks for sending that in. All right, here's Angela Del Prado. So I got a judgment against me in Colorado. So I've got two people from Colorado today because I couldn't come up with the money to file an answer. I think someone else is trying to serve me. What happens if I get another, if I get another judgment against me? I have no job, no house, a car worth about $300, trying to get blood from a stone here. So Angela, very sorry that you're in this situation. Let me just make sure I understand. We got one judgment already against you. And now somebody's trying to serve you with a second lawsuit. And so if you have no job, no house, no car, no assets, I know we got a car worth $300, but probably in Colorado you have an exemption that would protect that car. But if you have no other assets, they can't get the money from you. At least in Alabama, though, they can have that judgment against you, and this would be two judgments, and they just sit there and they get bigger and bigger and bigger. And ultimately, after 20 years, those judgments go away. Technically, it's after 10 years in Alabama, but they can revive them for another 10 years. So find out what it is in Colorado. But they'll do that because maybe you'll inherit some money. You'll inherit a piece of property. Maybe you get back on your feet. Now you got a great job. Now you got a house. And they got those judgments that start off here and they just get bigger and bigger and bigger. There's the rule of 72. I think I did a video on this. If you find out the interest rate that judgments make, and in Alabama it's 7.5%, or the contract rate. So I've seen some where they request like 36% interest. if you divide that interest rate into 72, that tells you how many years before it doubles. So if it's 36% interest, it doubles in 2 years. So you get a judgment for $5,000. 2 years, it's 10. 2 more years, it's 20. 2 more years, it's 40. You see how this just keeps getting bigger and bigger. And so they do that because they say maybe you'll come into some money. Maybe you'll come into an asset. Maybe you'll get a great paying job. And we'll be there with this massive judgment. So what I would do, talk to a lawyer in Colorado. Find out how you defend this on your own. Because if you, let's say you represent yourself and you go down there and fight and you lose. So what? If you don't answer, you would have lost anyway. But maybe you win. Or maybe you can get a great settlement. Or maybe you can catch them in some violations of law and then you can sue them under the FDCPA. So I would definitely get with a lawyer there in Colorado and hope things get better for you. So here we have Alpha Master James. Great video, John. I was wondering about this topic. I hate Discover. Okay. Yeah, so I know James has not had a fun time with Discover. And we certainly have sued Discover a lot of times. So I understand the feeling there. And appreciate that comment, James. So this is Ken Farrow. This video is what's a motion to enforce settlement agreement, which that can be in any number of contexts. Could be a personal injury context, could be a settlement where you sue a debt collector, where you're sued. So a motion to enforce settlement is just where you go to the court and say, we have a settlement, but the other side's not performing, make them perform. So let's see what the question is. I'm a plaintiff and the defendant filed a motion to enforce. They hit and totaled my car and her insurance company offered to cover the gap left after my insurance paid off, which I was suing the defendant for. So the gap being, $10,000, the car's totaled, it's only worth $6,000. What about that $4,000 gap? So Ken sued on that. Her insurance called me the day before the court date, offered me a check for the amount I was asking. So that's great. I agreed. Then I was told after the court date that if I accept the check from them, that their insurer will be released from liability. Yeah, if you take a settlement, then that's it. So you do have to be very careful about making sure that you want this to be completely done. Now, I'll say this. Normally in a car wreck case, I've been doing car wreck cases since I became a lawyer in 95. I mean, I helped on them even before then, but so 25 years or whatever. Most insurance companies, there's a personal injury side, or they call it bodily injury, and then there's the property damage. So if they're only paying you for property damage, they don't try and typically in the same check take care of the bodily injury. But if you sued them only for property and they offered to pay you exactly what you sued for, then that would be the end of it. So say I had no clue what that was, nor was notified of that beforehand while they were offering the check to me. Called my insurance. They told me not to accept the check, so I didn't and continued my case. What are my options? Okay. So now I understand. So you sue in a car wreck case. You're only asking for that gap for the property damage. In my example, $4,000. They offered that to you. You accepted it. Now they want you to sign a settlement agreement or release them from liability. Well, a couple things. If you're offered everything you've sued for, then the case should go away anyway. And once it goes away, that you can't sue them again for that. So I think my question would be, what is it that you're wanting from this person besides that gap between what your car was, what you owed and what your car was worth? If you're not asking for anything else and they're giving you everything that you want, then I don't see a problem in taking it. But if you're worried you may have some personal injury, then yeah, you've got to get with a lawyer on this that does personal injury. Now, if you're in Alabama, you can call us 205-879-2447. But if you're in another state, find a lawyer that does personal injury and see, did you make a claim for personal injury in your lawsuit? I'm assuming you filed your own lawsuit. I mean, if you have a lawyer, definitely get with your lawyer. But it's a little puzzling because normally if we're only suing for property damage and they offer that, then that's great. You get exactly what you want. But if you're suing for something else, then yeah, you don't want to settle for less than what you're entitled to. So bottom line is I get with the lawyer because if you agreed to take a check, they can enforce that. In Alabama, it needs to be in writing. Okay, so I think here it was, called me the day before the court offered me a check. Well, that probably is not enforceable in Alabama, but you have to check in your state. So best of success with that, Ken.